as they sort out my presentation online, I could start by giving you a bit of context. So this presentation is the beginning of some reflections that come after a thesis, a doctoral thesis that I presented many years ago. I shall not reveal how long ago. And so with the discussions on Ubuntu and having read my thesis, I now think that this may be the moment to rewrite it and look at it, well, rewrite it as an article and view it in the eyes of Ubuntu. And I'll tell you why. So my presentation is titled Protection of Community-Based Water Governance Systems. So I'll just start and hope the presentation comes on. So just to give you a little bit of a background, so my study was on a community called the Marakwet community, part of the northern part of Kenya. The Marakwet live in an area that suffers from water scarcity. And for the longest time, from early 19th century or even earlier, they relied on irrigation furrows, a system of irrigation furrows which they had established themselves, and they had a very clear way of managing those furrows. So some form of customary law, depends on how you define customary law, but a very effective way in which they manage the furrows. So they had clear rules on who used the furrow, responsibilities with respect to how you would construct and repair the furrows, the extent to which you were able to access the furrows, a lot of which was dependent upon how much work you put into the furrows. So how much you contributed to the community's management of the furrows determined your accessibility to water resources. There was also serious sanctions in terms of members who went against community rules on management of the furrows or just, management of the scarce water that was available. It was also interesting how communally, the responsibilities of looking after the furrows, of course, were entrusted to male members of the community, but where a woman became a widow and had no sons, there were like very clear systems of getting the rest of the members of the community to contribute to her section of, the kind of work that was expected of her family. And that would actually allow her to gain access to the scarce water resources. So then with time, what happens, and probably you can go to slide number 2. So with the passage of time, customary law governance systems in Kenya start to fade away, and little by little are replaced by the statutory systems of water governance or natural resource governance, let us call it, and institutional frameworks that are built on those laws. And then that, of course, has its implications. So next slide, please. So a number of years later, so fast forward, and we see a total change. So as we say, customary law is fading, statutory law systems are taking precedence. So what happens is that the community becomes more and more reliant on government in terms of solving their water scarcity problems. And those of us who may know of the community and some of the things that have happened in the recent past know that national government promised this big project to the Marakwet community that was going to transform their lives from the perspective of water and irrigation. So the government was going to construct for them a dam called the Aror Dam that was going to serve more than 50,000 people in the region. So it was going to scale up entirely the whole furrow system. A number of years later, well, in order for them to achieve it, 900 families were approached and were convinced to cede their land to the government for purposes of getting the big dam created, or constructed. And that land was being given in exchange of 6 billion shillings that was going to be given to them as compensation. Unfortunately, their road dam never was. So as we speak, all we have to show for that dam is probably a small hole and senior government officials under investigation for corruption charges. So what ended up starting as, the solution for the Marakwet in terms of water has now become a persistent source of water scarcity. So an ongoing persistent scarcity of water resources. And, all the things that come with that. Yeah. So conflicts within the community and this particular community and others. So on the basis of that, I asked myself a question. Yeah. So I began to think, suppose there was a way of integrating the customary law systems into the statutory framework for governance of water so that we would keep the best of both worlds. Yeah. So undeniably, life was not going to continue as it was in the beginning of the 19th century. And that wasn't, the proposal that this particular study was making. Rather, what the study was seeking to achieve is, can we pick out what was some of the reasons why the law was sustainable, the customary law was sustainable, why it worked, and then find ways of effectively integrating it into our statutory forms of water governance. As you know, in order for you to have a good law, you need to start from jurisprudence. You need to go back and ask yourself the basic questions such as, what is law? What exactly does a conception of law mean? Because that then helps you in terms of theorizing and coming up with the practical manifestations of those concepts of law. So that's the question I asked myself. So is the lack of a clear jurisprudential basis, where jurisprudential basis here includes the legal concepts as well as the theories, for customary law at the root of the integration process? And I had the previous speaker made a reflection, which I think all of us agree on, or well, most of us, which is that Western academic legal thought was often accused and has been accused of an inherent bias. So generally, jurisprudence is often considered in the context of Western legal tradition, with non-Western legal traditions regarded as marginal and unimportant. And that to a certain extent explains why then I did not look at this particular question through the eyes of Ubuntu. So whereas, yes, there was the appreciation that perhaps the Western jurisprudential thinking was not a good basis for conceptualizing and theorizing customary law, it was a struggle to see, well, what kind of other legal concepts or theories could redefine the legal systems for water governance in this country, and therefore find ways of integrating the statutory together with the customary. So basically, it was a question of theorizing customary law while seeking a fit for purpose in terms of the concepts and the theories. So beginning with the concept of customary law. So as I said, this community had these irrigation furrows which they managed way before the colonization of Kenya. So obviously the furrow systems and the customary law system that managed those furrows was happening within the context of a pre-colonial, then colonial, then post-colonial legal systems, legal regime, with all its jurisprudential basis in Western jurisprudence tradition. And it's interesting to see some of the conceptions. Please move on to slide number 6. So it's interesting to see the conceptions that those legal systems had with respect to customary law. So even at the level of legal concepts, there were clear mismatches between what exactly the community understood as customary law, how it operated, and how customary law was perceived and defined in these colonial systems of governance. So as the colonial masters came in, of course, initially there was a lot of bias, yeah, and perhaps we can excuse the bias from the perspective that there was a lot of ignorance in terms of this new continent, the context within which these furrows were being managed. And of course, there were prejudices in terms of how the law operated, because sometimes the sanctions seem to be very harsh or outside the limits of what would be considered as acceptable in that particular tradition of law. So then during colonial rule, of course, it was clearly, it was clear that there had to be a recognition. You couldn't wish away customary law. So what then ended up happening is, initially there was toleration, yeah. So you can't wish it away, but the least we could do is to tolerate it, or rather the most we could do. And one of the major limitations with respect to how much the law was tolerated was what in Kenya has often been called the repugnancy clause. Yeah. So there was a clear preconception and perhaps misconception that there were certain native, quote, quote, customs that were repugnant to justice and morality. Now, having recognized that, so of course, that's why I talk about toleration. So having recognized that, there still was this understanding and reality that you could not really wish this customary law away. So then really, it was determined that customary law could be used as a guiding principle, really, for making judicial decisions where it was convenient. Yeah, so sometimes dispute resolution, for example, was a real nuisance, yeah, in the judicial systems of the colonial rule. And therefore, in such instances, it just made more sense to, let the people resolve the dispute as they are. So, so it's ironic that all this is happening against a backdrop of a system of law that recognizes common law. Yeah. So, of course, we know that the basis of common law is, customs and practices that of immemorial usage and therefore are accepted as part of law. So whereas that was expected to be the basis of the law that was governing this particular community and the rest of the Kenya, that common law was expected to be their law, yeah, regardless of the fact that it was the laws and customs of another. Yeah. So those are the kind of questions that led me to start asking, okay, so wait a minute. That's the origin of our concept of customary law. Now, at some point in the 1960s, it becomes clear that many of these African countries are going to gain independence. So in Kenya, the question, and it was just in Kenya, it was in East Africa, and it was happening in many countries. But now talking about Kenya, conversations on customary law start to take center stage. So there's some famous articles by Eugene Cotran, in which summarizing what was being discussed in the London Conference of 1960 begins an attempt to show how, yes, there's this now, conscious intention, deliberate intention to see what exactly do we do with customary law, yeah, as we develop and, pass on the laws as the countries gain independence. So I'd encourage you, if you get a chance, to read some of those deliberations in the London Conference, because then they show you all the prejudices and the bias and how it was interesting to have a conversation on customary law led by outsiders who had never, didn't have the contextual knowledge, may have had but limited, but we know almost never been a part of, so they were never governed by that law that they were trying to define. So like I say, as they're trying to figure out how do we deal with customary law, nobody wants to leave it. So of course, those who are taking on, those who are gaining independence want customary law somewhat included in the laws of the nation. And then of course, those who are leaving, that's the colonial masters, decide, okay, so let's join together and see if we can come up with projects of consolidation and codification of what was customary law. Now, scholars, including then, started to criticize how this whole codification process was happening. And one of the critics was Twining, who I think made a very good observation, although Cotran subsequently challenged his perspective of what was happening. And he said what he could see was, because of the speed within which this study had been done, practical utility started to take over pure research. And of course, as a result, again, you end up with an inclusion of customary law in legal systems of governance, that is statutory systems, without a clear conception of what exactly customary law is. Fast forward, next slide, many years later, Kenya then promulgates the 2010 Constitution. I put the autochthonous with a question mark because, this Constitution has been lauded as one of the great novel constitutions, or one of the modern day constitutions, let us refer to it as thus, because of the fact it is homegrown. Yeah, so the process of coming up with a constitution was, was structured along going down to the communities, getting the communities to give their feedback, and therefore coming up with a law that was really and truly a law for the people and of the people. So then reason for autochthonous coming in question mark is because of the fact that when I did this study and went to the Marakwet and had conversations with people, because there was an element of social science research, it was amazing how many of them had very little, yes, they did know that there was some public participation that happened during the process of coming up with the constitution, but few of them had actually been a part of these conversations. Yeah, so interesting again, because, okay, so which people are involved? It's also interesting to hear how the Kenyan constitution has often been compared to the South African constitution. And in fact, there have been instances where there's claims that there was too much borrowing. Yeah. So again, to what extent is it homegrown? That notwithstanding, there was development in terms of the recognition, either implicitly or explicitly, of customary law. Yeah. So the Constitution recognizes customary law as a source of law, no repugnancy clause in the Constitution. So the only limits to customary law as provided in the Constitution is with respect to inconsistencies, which cuts across all other sources of law. So any law that is inconsistent with the Constitution is invalid, customary law included. Now, interestingly, the definition of customary law is not given in the Constitution. I looked around, and one of the laws which I thought can be a really good basis for building the customary law systems, or recognizing and appreciating the customary law systems for managing those furrows, is what is now known as a Protection of Traditional Knowledge and Cultural Expressions, an Act of 2016. Now, interesting again is, whereas the Act attempts to define customary law, what it does actually is to state what customary laws should be like. Yeah? So it says customary laws and practices mean customary laws, norms, and practices of local and traditional communities that are legally recognized in Kenya. So back again to the question of, so what exactly is this concept of customary law? Yeah? So yes, we know what exactly it is that will be recognized. We recognize that there is customary law, but the definition of the concept of customary law continues to be elusive. So the Act, like I say, has lots of benefits because it recognizes the fact of traditional knowledge, and therefore would be, a great opportunity to gain from the learnings of those systems of governing the furrow systems and see, how can they be a solution in terms of integrating. So then, of course, like I said, good laws have to be conceptualized in theory. So while studying, I thought, let me attempt to find a legal theory that will respond to, or that better contextualizes, or is more fit for purpose for this whole discussion on customary law systems and the governance of water resources, integration of the two so as to protect the water resources. So I sought a possible foundation of the concept of customary law in Aristotelian philosophy. Now, I must state here that not being a philosopher, rather a lawyer, perhaps this discourse in the context of Aristotelian philosophy had its own limitations and shortcomings. So there was a lot of inspiration that came from Amanda Perhosa, whose name I've put down there, and may her soul rest in peace, because she subsequently succumbed to a long battle of cancer. But around the time actually I was conducting the study. But reading her works gave me a lot of inspiration in thinking, look, let's get outside, jurisprudence as we knew it, and let's see, can we go back to the beginnings of Aristotelian philosophy, try and understand how the concept of custom was discussed in that space, and I saw some characteristics which I felt could form a basis for discussing the concept. So one of the things I think I observed as I started to read Aristotle through Amanda and through also Bernard Murphy, was the fact that Aristotle has the capacity to use one concept, to have one concept that has sub-concepts, for lack of a better way of expressing it. So he can use one word analogously. So speaks of a particular reality, but in other instances uses the word to refer to a different reality. Now, that's one of the things which I think is very comparable with the notions of customary law that I gained while listening to the people of Marakwet. So when you attempted to box the definition of customary law, you would get stuck because there were nuances, and the fact that there was no clarity or unequivocal definitions did not mean that there was no truth or that there was a problem. So looking at the notion of custom, from Aristotle, I saw these two ideas which I thought could help. So, well, Aristotle, dealing with the notion of custom, defined it as, or included the idea of ethos or ethos associated with the natural inclinations or passionate nature of the person, which to a certain extent could be compared to conventional customs, and nomos, which is associated with mind and reason. Logically speaking, we would read stipulations and, deliberate stipulations of law. However, as discussed by Murphy, Aristotle then seems to confuse us, because in subsequent works, he uses nomos to refer to both the deliberate stipulations as well as the customary conventions. So then the apparent distinction between customary law and law, as is indicated in the history of statutory law systems in Kenya starting pre-colonial, I feel is misleading. And that law, understood as practical reason, can actually include both concepts. So law, statement that helped to have a basis, a legal concept that could better describe customary law, was the appreciation that law is a form of normative deliberative practice, just as customary law is, insofar as it is a product of a process of thoughtful public adjusting of norms to changing circumstances through a practically oriented, discursive and normative practice. Sorry for that, it's a bit of a mouthful, but the idea was to demonstrate that, there was no need to see customary law as a thing of the past, that customary law was living, and that there's a jurisprudential basis of removing that distinction between customary law and law, and appreciating that just as statutory systems come through, deliberate stipulations, well, customary law systems also came through deliberate discussions and discourses amongst the community as to what would then become the laws, the rules that would then manage the pharaohs. Now, I did actually give a thought to natural law jurisprudence when looking at customary law. And unfortunately, in the context of Kenya, when you say natural law, it seems not to sit too well with customary law. Now, obviously, we could say that perhaps it's because of oversimplification of natural law, so as to, see it as a theorizing that necessarily starts with a moral foundation. And then remember that the term morality in the context of the Kenyan jurisdiction, the Kenyan laws, pre-colonial laws, was a bit of an uncomfortable word, because its historical conception actually formed the basis of misusing the term morality to foster injustices, and unfortunately, it also justified certain property law alienation practices. And one of our legal scholars, the late Okoth Ogendo, developed that thought to a great extent. So as soon as you talked about natural law theory, immediately supporters of customary law would begin to ask, well, whose morality, whose justice? Further, I think the coexistence of natural law, again, this is a historical issue, and the concept of terra nullius in Australia also starts to challenge among Indigenous peoples that the capacity of natural law to form a jurisprudential basis for Indigenous or customary law systems. In having said that, so where are the reflections? Where would the new reflections with respect to the rewriting of the arguments that were made in this paper start? And in my mind, Ubuntu may be a jurisprudential context for theorizing customary law moving forward. And this, like I said, is just a beginning. So it is my sincere hope that the conversation continues, and I look forward to any feedback that could help advance that conversation. Thank you very much.
Thank you, Dr. Gachenga, for that presentation. I would invite questions from the audience, starting with one from myself. So my question would be, at the very beginning, as you were describing the water governance systems in the Marakwet community, it sounded a lot to me like something that Sir Thomas More describes in his Utopia about the things that everyone is set to do and the punishment that comes about as a consequence of not fulfilling your duty. And my question therefore would be, what is there room for accommodating the human being sorry, as a person who is flawed within the idea as well of Ubuntu in that kind of governance system?
Thank you very much for that question. So yes, it's true. Usually when you look back at a customary law system of governing, we can become a bit idyllic. You know, the separation of time can suddenly make us think life then was perfect, and it wasn't. Yeah, so there were flaws in that customary law system of governance. And of course, some of the fundamental flaws were treatment of treatment of women, yeah? Because, well, inherent in the cultures of those systems was unfortunately injustices against women, etc. And even just the way some of those sanctions were carried out were flawed. Yeah, so sometimes, unfortunately, the punishments would lead to death. Yeah, so which of course isn't the way to go. So yes, I agree with you, and maybe I should have made the point clear that those systems of law had their own flaws, and perhaps a discussion on Ubuntu can then help us to have a jurisprudence that appreciates the benefits of that customary law system without negating the fact that there were flaws. There were flaws in the system.
Thank you very much for your response.